At, oh my goodness, my watch technology, 9:01 a.m. So Adrian, if you can call roll, please.
Coulter? Here. Esben? Here. Hershenson?
Here.
Lester?
Here.
Levin?
Here.
Shepard?
Here.
Torre?
Here.
Everyone's here.
Thank you, Adrian. At this time, we have an opportunity for the public to make any comments. And so I don't know if we have any members on the phone or any members present. If so, if you could just identify. So hearing we have nobody on the phone, we'll move on to the rest. Actually, I think we should take a second because we have a number of people in the room. So I would kind of do a second to do some introductions around the room. Or is that agendized down here?
That's part of the agenda.
Part of the agenda. Well, then never mind. We'll go back on topic. So let's go to section 1 then for staff reports. And with that, Amy, I will turn it over to you to do a staffing update.
All right, wonderful. Thank you. So good morning, everyone. I think at the last 2 or perhaps even 3 CBLS meetings, I discussed the fact that we have been in an active recruitment for both a program specialist as well as a program supervisor. And we have recruited for those 2 positions, and those 2 new staff members are here. But as part of that, I also thought it'd be nice for us to meet the other staff. So this is the legal specialization team. And so with that, I'd like to introduce to you Rowena Espinoza, the new program supervisor. I don't know if you want to share a little bit about your background, Rowena, and how you arrived here at the State Bar.
Hello, good morning, everybody.
You might want to hit your mic.
Double click at the bottom there.
Double click at the bottom.
There you go.
All right. Can everyone hear me now? I'm Rowena, and most recently I came from higher ed, but prior to that I was with the district courts for about 16 years, and I'd wanted to return back to public service, so I applied for the job, and thankfully I got it.
Thank you, Rowena. We also have Wes Galen.
Hi, I'm Wes. I've been with the State Bar for 10 years. Recently was doing with the MCLE department. So I did the process of the continuing legal education, the suspension, the reinstatements, and helped individuals with MCLE questions and what have you. But prior to that, I had 18 years of working in the legal firms throughout San Francisco, some big firms, small firms. So I'm very familiar with the work here, and this is my second week on the job. So thank you for coming over, and it's nice to see the faces with the names now that I see on the forms, and it's kind of nice to put the faces and names together.
Welcome.
Thanks, Wes.
Thank you.
All right, and with that, maybe we can go around and each group introduce themselves. And this is our staff that has been on board for at least a couple of years, and also maybe talk a little bit about the work that you oversee or the functions that you carry out for legal specialization.
Hello, my name is Janelle Dela Cruz. I'm a program specialist. I oversee 4 of the specialty areas. I take care of workers' compensation, estate planning, bankruptcy, and taxation. Thank you. Hi, everybody. My name is Elizabeth. I oversee 6 specialty areas: criminal law, family law, franchise and distribution, immigration, legal malpractice, and appellate.
Adrian Galang, I work with you guys.
Crystal Bending, I am the outgoing program supervisor for the legal specialization department. I'm still at the State Bar, though, with the Office of Access and Inclusion.
We also have our Office of General Counsel, so we have a new member and an outgoing member, so perhaps you both can introduce yourselves.
I'm Caroline Holmes. I just started with the Office of General Counsel, and I'll be taking over for Dusty, doing advice and counsel for admissions, including legal specialization.
Hi, and I'm Dusty Overpeck. I've been at the last couple of meetings, but I'm retiring 2 weeks from today, so I'm turning it over to Caroline.
Congratulations.
Thank you.
Yeah, hence the smile.
Yeah.
All right. Okay, so the staff is going to stick around for the staffing portion of this agenda. So with that, I think we're going to talk about the implementation of the legal specialization programs. Again, these are the board directives related to Appendix I. And so I want to highlight some of the steps that have already been taken and then describe where we're at with the remaining items or directives. So the first is updating the State Bar rules. The first, again, these were rules that came to the board in March, and they were finalized and approved in May of 2019. So that task has been accomplished. Sunsetting the advisory commissions, we reported this at the last meeting. That was completed in June of 2019. Yes. Yes.
About the rules that were passed?
Yes.
Was there any comment with regard to the comments we sent up with respect to the undivided loyalty portion?
Yes, good question. So that language was directed at the conflict of interest policy. The conflict of interest policy, the revised version, that was going to be it was a global recommendation for all sub-entities to replace any entity-specific, sub-entity-specific rules of conflict of interest rules. They did not proceed. So currently, the conflict of interest rules that CBLS had originally remain.
So that part was not adopted?
It was not. All right. Now, the next item is establishing a paid position for exam development with advisory commission members. And again, this is the idea is to create efficiencies with the remote technology and using graders that don't necessarily have to be local. That item was completed in June. We're still in the process of recruiting for graders in certain areas, and you'll see this in a few slides, where we're having some challenges in identifying graders in certain areas, and we're doing some outreach in response to that. The other was to automate the exam administration through AIMS, and this is ongoing. We have been using a combination of paper and AIMS as an enrollment process for the exam administration. Now, once everybody's registered and assigned to the exam, we plan to use AIMS for the grading process and the results distribution. Yes.
With respect to the AIMS program, we know that Cynthia was significantly involved. Does Cynthia still play a role in assisting the State Bar with the AIMS program? And have there been any issues? Are there specific staff that have been trained in the use of the software that's being used? I believe it's a Salesforce software, and so on and so forth.
Oh, yeah. I have an update on the AIMS system because post-adoption, we have had some issues surface, and I'll describe those in the recent developments portion of this. But essentially, the system that has been implemented and some issues have come up that we need to address, and I'll describe those later. And then we could also describe everybody's role in that the next set of activities. Okay. Now, the next item is establishing legal specialization exam and development team. That was completed in July of this year, so a few months ago. If any of you are familiar with Dennis Mayo or Chris Frick, who have participated as consultants on the legal specialization in prior years, they have been invited to join as ledge team members, are helping with the exam developments on all of our exams currently. All right. The next item is establish a pool of graders that I explained earlier. It's an ongoing process, so that we're seeking to recruit for paid graders from our pool of advisory commission members. The other is to develop an inventory of exam questions. We are in the process of that, so we do have a bank of questions that we're using for this next round and previous questions. The idea is to buy an item banking solution or solicit for an item banking solution that will help us keep things electronically with corresponding documentation as to the status and feedback on each of the questions. And this is incorporating things like drafting feedback, pre-testing feedback as we develop these exams for future years.
I have a question.
Yes.
With the demise of the advisory commissions, how does the State Bar intend to keep the questions current as the law changes?
Oh, yeah. So that's exactly what an item banking solution would do. So, it's modeled after what we do for the bar exam. So we have a bank of questions. We would use each of the ledge team as well as pre-testing and drafting team to pull from those and keep each of these questions up to date, current, and each of these pools of folks would provide us feedback like we're doing right now for this past exam.
Are there going to be 11 different people who will be participating in that from the 11 different areas? Yes?
Yes.
Are they going to be paid?
Yes. Okay. All right. The last initiative that we have is developing the working group for the certification and recertification process. That's what I want to highlight here today. So again, oops, are you doing that? Okay. So the goal of this working group, again, was to make use of expertise and practical experience of current specialists to help with the review of complex applications for certification and recertification. We have rules that have been incorporated, as I mentioned earlier, that reflect that process. And so we also want to ensure that regulation is conducted in the public interest for the purpose of public protection. So with those in mind...
I'm baffled.
Okay.
We have 11 areas of certification. Is there one person per area of certification that's going to be a paid specialist to know the entire area of law for purposes of making sure that the questions are current?
For drafting or for pre-testing?
I don't
we
care.
Have more than one person.
I'm trying to figure out who these 11 specialists are, only one of whom from each area is going to know the law for purposes of either drafting or pre-testing them or what?
Well, and maybe saying one person was misleading. We have at least one person in each of the areas. In some areas, we have more. I don't know if we want to dig into each of the areas, but there's at least one person that is both has drafted the question, pre-tested it, provided feedback once it's been reviewed by our consultants, as they have done in the past. And so there is just more than one person for each of these. And the advisory commission
having come up through the commissions, so I know that when we had 11 of us, maybe there was one or two that were savvy enough to understand where some law had changed, so we were able to tweak the question. But it took a whole lot of people to make sure that you were covering a bunch of different areas. And as I understand it, we're going to leave this to one person?
No.
Oh.
We have at least one person participating in each of these as either a pre-tester or a drafter.
Okay, I think you missed the point, and I think the point has been missed now for about 2 years.
Mm-hmm.
The point of the advisory commissions is that you had a group of people who collectively understood practice and procedure, that with all respect to all of you who are employees of the bar, except for you two, you do not understand the complexity that goes into this exam process, and that the advisory commissions collectively, you had talent, you had volunteers, you had people who believed in their profession and were motivated to advance the profession as members of the bar. I know we're licensees today, but as members of the bar. I don't see how this current iteration is going to protect the public interest and continue to protect the public interest when you don't have a collective group of people who come from different places within their own specialty to have created these exam questions. And how are you going to solve that problem? How are you going to protect the public interest as it has been all of these years with just one person who may not have the ability to understand all of the complexities of appellate law, immigration, trust in estates, bankruptcy, That there is no one person.
Well, and the requirements that we have passed and said this is what you have, this is the standards that you have to meet are so broad. There's not a single one on the Estate Planning Commission, for example, that had the experience in all of those areas. And you didn't have to in order to meet the qualifications, but collectively, because we had enough numbers, we were able to cover all of those credentials that you had to have, those areas of coverage. And so one person, this is what disturbs me. If one person is there and who's not out there practicing, they can't possibly know what they're testing on.
Well, and maybe I just want to clarify that. I think this is part of the misunderstanding, and that is the model isn't that different. We're not starting from absolute scratch. We have pulled people from the advisory commissioner. So if you look at who's participated in either the pre-testing or drafting, they reflect the advisory commissioners that have participated in the past. So no one was let go, and we're starting from absolute scratch. I think we have people that were advisory commission members that are now being paid for drafting and for pre-testing and overseeing the question exam development altogether. The paid consultants, as they did in the past, are also reviewing the final version of the exams.
Well, that part makes total sense to me.
Okay.
And that kind of professionalism is what we were ordered to spend some money on, so that those questions are fairer. Because as the practicing attorneys, we understand, we're on the ground. We know what's going on, and we, as commissioners, we were trying to write questions that maybe weren't as eloquent and fair in terms of testing. That kind of tweaking is great. I mean, I think that's wonderful for getting some consistency. The problem that I have is that the underlying piece of how you get the question, how you test for that knowledge and the currency of what's going on is what the underlying volunteers are dealing with on a day-to-day basis. And I don't see where we're bringing that expertise back into the fundamental spot where we're actually writing that question.
Well, if I may, I'd like a point of clarification. So you said at least one. So what is the actual rule in terms of the creation of the questions? Is it that there's a minimum of one expert in that specialty area, or is it that that's a recommendation? And how does that look going forward? Because I think, okay, again, as the public member, and we have two public members here, the idea for me is if I go to somebody that's a specialist, that they are up on what's going on. And in these areas of laws, as I witnessed at my very first meeting on this board, when we were going and looking at a review process, it was actually in the immigration area, there was potential some major changes happening as it related to an administration change, right, with the government. And so there was a real evaluation done on every one of those questions. And that really brought it to light, was like, wow, this is really something that's important. And so, you know, Donald is here and he knows those answers, but when you have 11 people sitting and arguing or discussing the facts, it is different. So I'm curious as to what is the actual standard that's being held to in terms of, is it one, at least one? Is there a minimum? How long is that rule in effect? And how can that be changed in the future, right? Because the oversight that this body has in terms of how this is going is diminishing. And so, you know, again, as the public member and for public protection, how do we ensure that in the future that we maintain the standard that has previously been there? Am I summing that up?
Thank you.
Well, two things. That we've tried to harness as much as that as possible. So when we recruited, we weren't recruiting for at least one person. We try to get as many advisory commission members to help.
I understand that's at point one, that point of time one, so today. But now that the commissions are gone, what's the pool for when these previous advisory commission members leave from this role, whether they retire or they don't want to do it anymore or they found other things? Where's that next pool, and how will you vet that next pool? And again, what's the minimum requirement for that pool to have?
Yeah. Well, and also that is what's going to come up because we have tried to solicit for drafting members or members to draft the questions, to pre-test the questions, and to grade. And I'm going to show you a grid where we're having a challenging time. But again, we're soliciting only from the previous wave of advisory commissioners. So we're probably going to seek out previous waves to get to a point that we have this. Part of the problem is if somebody volunteers today for this next exam, we don't have another exam for another 2 years. So how do
Right.
we keep this person
And you don't have
interested,
another
embedded?
advisory commission to pull from. That's the point that I was trying to make, is that the pool is drying up. So what is the next pool?
Yeah.
There you go. My concern would be more along the lines of the kind of the gestalt of all these exams. Like, how at the end are they evaluated for how comprehensive they are, how fair they are across the specialization? Because I think that the process that has been established is probably going to do a pretty good job on individual questions. But at least I found, and I don't know if other people could back me up on this, that the commission's most crucial role seemed to be at the very end. Okay, how many questions are going to be on this? How many questions are going to be on that? Will this exam overall give us a sense of whether this person should be a specialist? And that's that last piece where the whole exam is in a room with a group of specialists that know. It's like, well, like, just to use the appellate example, that's a little too much on record preparation. That's not enough on standards of review, that sort of thing. If at the very least the working groups are rolled into this for the purposes of at least getting multiple eyeballs of specialists on these exams, just to tell us whether or not, as a whole, they're actually not necessarily fair. Because I think most of the questions are going to be fair, but like, for instance, in appellate, if 3/4 of our questions were about record preparation, and we're not talking about, like, standards of review or something like that, then like that doesn't tell me whether this person's a specialist. That this person might have just gotten lucky and gotten a bunch of questions as to a portion of appellate practice that they know very well. So I think that might be the biggest part. And I've harped on the working groups in the past, to like trying to get eyeballs on all applications and stuff like that. Like that, it might be an additional thing that we'd want the working groups to just see at the very end. It's like, hey, by the way, this is the exam as it's intended to be given. There's 3 of you, 5 of you, however many there are. What do you think? And maybe 1 or 2. They may have differing takes, but that seemed to be like the biggest role of the exam preparation was just actually putting together the balance of the exam as opposed to individual questions.
Yeah, and I just want to follow up with, that's how we did it at the BLAC. The exam would come together, we would look at the exam as a whole to see that the exam was testing whether or not someone had the proficiency to be a specialist in bankruptcy. I've heard a lot talk about the bar exam, and what I've said now repeatedly is that the bar exam is, do you get the key to come into the door to get a license to practice law? But the specialist program is, do you get a key to go into a door that has a special room that the public will go to seek out that specialist? It's a very different type of exam. And it's apples and oranges to compare the bar exam to the specialist exam. The specialist exam, and I've talked to a lot of people over the 10 years that I've been doing this as a volunteer, where I've written hundreds of questions that you're going to use. And I've said to them, go to work. This is an exam to test you whether when a client comes into your office and sits down and begins giving you the facts of their case, are you going to be able to spot those issues and advise them without committing malpractice? That's how this exam, all the exams are written. The bar exam is not that exam. And so, again, how is the state bar, which has a mission of protecting the public interest, and whether or not this organization, the specialist organization, CBLS, how is it going to protect the public interest when there are lawyers out there who are saying they do appeals, they do trust in estates, they do bankruptcy? How are you going to protect the public interest so the public understands the difference between someone who is a dabbler in an area versus someone who's committed their profession to being a specialist? That is the concern that we have always had. And that, as a volunteer, that's why I volunteered to do this program, to protect the public interest. How is the State Bar going to protect the public interest in what we're talking about here? Because we don't see it. And I think I speak for all of us, we don't see it.
So, based on what Aurelio just mentioned, in terms of the working group at least being the last set of eyes at looking at the exam, I mean, this is something that we could definitely explore with our working group. I mean, right now they're designated to look at the certification and recertification applications because, I think implied suggestion is that we bring back the advisory commissioners, and that can't happen. Our next measure, our next model would be something like the working group and bringing that task to the working group along with the consultants, as has been the tradition with the legal specialization exam. So all this to say that there is nothing that deters us from bringing it to the working group if that would be appropriate for them, whatever size that working group is. I think we talked about at least having a minimum of 5, but as you'll see, we're struggling getting at least 1 in some of these areas. So my suggestion is that would be, I think, a doable or feasible solution to address the issues that you've described here.
What if you can't?
What if we can't?
What if you cannot get a group of 5 people together who we otherwise would get together as an advisory commission? What is the plan? This is a very large organization, lots of smart people sitting around this table. What is the plan if you cannot get 5 people together as a working group to go over the exam, like Roy said, to go over the exam, that it's a balanced exam that is going to test for the proficiency of a specialist? What if you cannot get those 5 people together as we used to be able to get 11 people together as an advisory commission?
So perhaps we weren't able to get them as working group members. But perhaps what we could do is we have at least 5 in terms of drafting and pre-testing, and they would wear multiple hats, and so they would provide feedback as a pre-tester on the questions or help draft the question, and we could pay those people to look at the overall exam itself.
Yeah, I'm sorry, I have to jump in on that because from a finance and accounting standpoint, you don't have the same person paying the bills that's reconciling the statement. They're going to see the same. They're going to see it the same way both ways. So you need to have 2 sets of eyes anytime you're doing an audit of a process. It can't be the same person. That blows up. So,
but I thought the oversight was about the balance of the exam itself, so that it is comprehensive. So what I'm suggesting is somebody who's either authored the question or pre-tested the question to look at the balance of the overall.
I would love somebody with different. I mean, because somebody that comes in fresh has a completely different perspective, and especially if they have experience with being on the advisory commission, however many years it might have been back from the time they're looking at the exam. Another thing I would say is that I've made my peace with the fact that the advisory commissions aren't coming back. We know that, and I think we probably need to make our peace with the fact that there are going to be sacrifices we make vis-a-vis the quality of these exams. And I mean, I think that a lot of the discussion we've had is just like, how are we going to essentially make as high quality an exam as we did in the past? I don't know if that's possible with this structure. I just don't know. And I'm saying that not necessarily as a value judgment. We're down a road where we're trying to streamline these things. I completely understand those concerns, but we're trying to. I think we're kind of trying to patch up the plane in midair as opposed to just finding a nice place to crash land. I mean, it's very hard to do that, and I think that all the things that have been mentioned in this new process, I think all of these people are going to be competent and well-meaning and very able to do the things we're asking them to do. It's just the very structure of it.
Yeah.
When they're not looking at the exam in the same sort of way. We have people looking at certain questions and not others, and there's not going to be that collaboration in the room. We're going to lose a lot of what balance these exams. And in the end, I think that's the path we're going down. I have made my peace with it. and we'll go from there. But I think at the very least, what we need to do is get that last set of eyeballs on it. So, people that haven't even been necessarily even like working on the exam, it's just like, look, it's like, here's the exam. Here's the whole exam. All the multiple choice and all the essays. Does this exam make sense?
Well, and eventually you're going to run out of people who have history on a commission and how this worked, and you're going to be left with nobody except those who write the exam or write questions, those who grade the questions, and I don't know how we're protecting the public.
Can I just jump on that because it's relevant, is that you're already having trouble getting 5, right? And that's from a pool of a larger audience, if you will, a larger universe. And so as that universe is shrinking, what does happen next to Lou's point is what's the process? If now we can't get 5, what if we can't get 1? Does that mean that specialty goes away? What happens, and is it documented? We've thrown a lot at Amy.
Yeah. And what I'm going to just follow up with Rob is that what I'm hearing is a decision was made to dismantle the commissions, and I'm like, I'm fine with that. I'm not fine with that, but whatever. But I deal with a lot of business, and when you're setting up a business and you're trying to run a business, if you're going to make a decision to pivot, you have a plan to pivot. And what is your plan? And what I'm hearing is you do not have the answers. Because I asked you, what if you don't have 5? Well, maybe we can do this and maybe we can do that. For God's sakes, you have 330,000 licensees, members, whatever you want to call them now, and you have over 5,000 specialists, and you don't have an answer. You're running an organization with, what's the fees that comes in from the specialists? $1.8 million that comes in from this, and you don't have an answer on how to pivot and where you're going to go. If, for God's sakes, you take out a Google map and you can figure out how to go from point A to point B. I'm not hearing is you don't know how to go. You don't know where you're going. And I have some very grave concerns as both a member of the bar, and I am a member of the bar because a judge excoriated me when I said I'm a licensee. Okay? So whether you like it or not, the court's considering us members of the bar. And what are you doing? You don't have the answers. And I'm sorry if you're on the hot seat, Amy, okay? And I'm passionate because I have volunteered at this for 10 years. I have more time into this than anyone else. I've written hundreds of exam questions, which I volunteered, for which people are getting paid to do right now. And I don't hear an answer of where you are going. You don't have a plan. If you don't get 5 people, where are you going? You don't have a plan. Well, maybe we can do this and maybe we can do that.
Can I clarify a couple of things? Because I'm worried that at this point we've debunked the exam that's currently in process. So for the exams that are coming up this October, we use the advisory commissions to both draft and review the entire question. So what you're asking to do, to have somebody draft and a separate set of people review, that's exactly how we've conducted this exam right now. So the same people who participated in drafting and pre-testing have now reviewed the entire exam and signed off on it before it goes to the consultants. Exactly how we've done in the past. So this exam is not... we have no concerns about the quality. It's been drafted and pre-tested exactly like it's been done in the past.
It's not this exam. It's not this exam.
So,
let's give Amy a minute to respond to.
Right now we're having a hard time getting to 5, whether it's a working group, whether it's graders, or whatever the case is. But however, we have 2 years to recruit. We honestly do. I mean, so perhaps if we have do a little bit more outreach within each of the groups, we can achieve that. I mean, we have 2 years before our next exam. We have a pool of graders that we're working on recruiting. At this point, we're using a psychometrician to determine how many graders we need for each of these arenas, for each of the exams. And it's also based on the number of people that enroll. I mean, we're going to talk about it in the closed session, where we're at on those statistics or those counts. But the point is that we are not jeopardizing this exam, and we're on the same page about maintaining that quality. And we're going to do that. We have some time to recruit. We're going to use the same pool of people and the same process. However, they're going to be more specialized in the sense that, I remember when we first brought up the ideas of how we're going to carry out the drafting and the pre-testing. We want people with more experience in the specialty area. So the notion that it's an outside person or a machine or whatever the case is, that is not the case. We're using specialists in these arenas. We want them to have a certain level of experience as drafters and as pre-testers.
Yeah.
So I just want to make that clear before we proceed, because anybody who's watching this might think that we're going into this exam with
Right.
something that doesn't meet the
We're not
same
talking about this
qualities.
exam.
No, that's it's an important point of clarification, and I think that that it's really what we're talking about is what is the plan for the future. And when we talk about we have 2 years, even Roy and I were joking this morning. I got up and I started working, and before you know it, I'm running late, right? So, and that's a very
years
short
goes
term, right?
fast.
So 2 years happens quickly, and I think that there's a lot of passion. Well, I know that there's a lot of passion coming from the board because today is the last board meeting for a number of our members who've been doing this for a long time.
Yes.
With the recent changes, we are losing some of that legacy, that knowledge, because I did not come up through an advisory commission. Well, I'm not an attorney, but I didn't come through an advisory commission. So after next year's term, will be the longest standing member of the CBLS. And so we're losing some of that history. So I think that there's a lot of passion here to say, what is the future of the program? And what I'm hearing is that we don't know, and there's a lot of, well, let's see. And so I think that is part of the passion that you're feeling.
And let me really quickly, let me disagree slightly with Lou, because I think we have a plan. What I think we're identifying are certain kind of structural issues vis-a-vis what many of us saw as members of the advisory commissions in terms of constructing the exams. Now, I think, frankly, the plan that we have in place, the one we're discussing right now, it may work. Frankly, we may not have a choice. I mean, we given that the advisory commissions have gone away, we're in an environment where at least a lot of us, from what we know, are going to be it's a less than ideal setting to construct these exams. And from what I think I'm trying to express, what I think Lou's trying to express, and others, is that given what we saw making these exams, the current plan we have set up, which is basically a lot of these things are piecemealed, different things, and then like the final exam, as the exam's getting constructed, there's really not a lot of collaboration between these groups to actually get the overall exam, balanced in the way that we used to in the past. That's the concern, and definitely this exam is
fine.
Is fine, and frankly, future exams could be fine. I may be Chicken Little on this. Like, look, I mean, I'm Lord knows I've been wrong on so many things in my life.
Well, thanks for the reassurance there.
So there you go. Yeah. As the future chair of the Board of Legal Specialization, you always want to hear that, right?
Yeah, exactly.
You always want to hear that, right? Yeah, that's fantastic. But I think that's what we're trying to express. That, like, look, the things we've seen, and this is across specialties.
Right.
Like, we've talked about this stuff before. We've all kind of seen, like, the exam is 95% done. And somebody's like, well, wait a minute. Like, look, that exam kind of crosses over that. We're covering too much of that stuff. And the commission has this aha moment. It's like, boy, that exam would have gotten out of there, if it weren't for just this collaboration, it would have gotten out of there, like, with a very imbalanced sort of.
So I want, because we're still in B1. So what I would like to individually, and the rest of the board could say, is like to at least have some sort of formalized game plan as a flow chart of if-thens. If we can't find 5, then we're going to do this. If we can't find 3, what is the future roadmap for developing the exams and going in some sort of formalized setting that can at least be discussed and reviewed versus, well, maybe we can do this, maybe. And that's not, I'm not picking on the words that you're saying. It's just, as is the oversight, understanding the process is critical.
And we're here to help. I mean, the whole reason we volunteered here is we believe in the process, we believe in this program, and we're here to help. We're trying to, make this the best possible program.
Well, and I think that all of the concerns are valid. I think that one of the things that we could do is add on the agenda as a standing item where we're at with our recruitment in these arenas, whether it's exam development or grading, so we can reach out to this group here as, members of these specialty areas to help us in our ongoing recruit or provide ideas or strategies, because this is going to have to be formulated organically. We know what the parameters are. We know what the rules state. We know what our challenge is. And, if we could come to this group and get some support, that would be very beneficial.
I think it's also important that we have a contingency plan. What's the backup plan?
Yes.
And, do we have, for example, a plan in place where the advisory board stays until we get that new membership in place? And
I
then
think the advisory boards are actually gone
They're
already.
gone.
That was finished in June.
Right.
So it still needs to be put on the table. The
Yeah.
contingency plan is required with any business process, and so we need to treat this like any other private
The
business.
ship hit an
Absolutely.
iceberg without lifeboats.
I'd just like to make
Poor Donald.
I'd like to make one.
Donald's been inhaling to try to say something
gonna
for a
forget my
while now.
thought. I'd like to make one suggestion going forward. Like, I know the advisory commissions are gone. That's never going to come back. Perhaps one in-person meeting, at least one in-person meeting by the working groups to review the exam prior to exam finalization. So that's not like bringing back the advisory commissions, but just as like, look, for the purposes of constructing this exam, they'll get it before this meeting, and however many it is of them, whether they meet in LA or here, just because there's a lot of value in meeting in a room and talking about these things and just hashing them out. And that's the thing. That's not that, and that may like I can already see some of the objections that's seen like basically like maybe bringing back the advisory commissions kind of in another form, that sort of thing. No, just one shot right before you finalize the exam, just to get like specialists that we respect and that we that have already volunteered for the bar to just bang their heads together for a few hours and figure out what the final form of the exam is.
And Roy, that's what I maybe didn't state it clearly, but that's what I thought when you guys brought this up, that it wouldn't be hard to add that to the working group requests. We talked about certification, recertification, but reviewing the exam in its entirety before it gets finalized is not out of the question. I think that's very doable.
Okay.
And I was just going to comment that a lot of the members of this board have worked their way through the advisory commissions, chaired, dedicated 7 years, 8 years, whatever, volunteer work with the commission. That obviously is going to be lost along in the future. As more new people come on the board, they may not have experience in the commissions. They may not have that specialized experience in a specific area of law. So I think that you're going to lose the ability to recruit people by looking at this table in the future because you don't have that expertise. Another point of clarification I wanted to ask you, Amy, was that you said that for looking at these individuals, you're going to look back at the last couple of commissions. Is that for the working group too, or is it?
It's for all of it, whether it's.
And when you say last couple, like how many years back?
As many as it takes to get a sufficient number.
Okay, because I think you all should go back 12 years and get a list of everyone together.
Okay.
And pull from that, because just because somebody's been off the commission for 4 or 5 years, I think that, they may be willing to volunteer and come back in.
Okay.
Because there is a lot lost by doing away with the commissions, and it does impact the exam development just because, I'll speak for immigration law. I can't imagine doing it with a smaller number of people just because, we all think we're very smart. I think I'm smart. I wrote exam questions, and other people came in and was like, that's stupid, and ripped it apart. And I'm like, oh, now I get what you mean. But in my mind, when I wrote it, it's like, that's a perfect question on that topic. And like in that area of law, there's like probably, you could subdivide that into 4 different specialties within one specialty. So people are not going to be cross-trained in all those areas. If you only have 1 or 2 people overviewing everything, it's going to be a concern. So, put together as big of a list as you can, I guess.
Okay.
So unless there's anything, one thing I wanted to throw to you is I know that for the CPA exam, my fiance actually I don't know if it was the Board of Accountancy or who did it, but they actually have a commission. They reviewed questions across the board. So it could be something to look at that they don't have the advisory councils, but she just sat for several hours where they reviewed questions for the CPA exam. practicing CPAs. So there is, some precedent out there in this licensing to look at. But
Okay.
just real quickly, anybody have anything that we haven't already said 5 times that they would like to say before we move to the next back to Amy?
All right.
All right, Amy.
Okay.
Thank you.
All right, no problem. So now our next area is the process. This is now the process for reviewing the certifications and recertifications, because that is a context that we've talked about using the working groups in. So going back to the rules that impact or that direct us on how we make determinations on certifications and recertifications, we talked about grouping the cases into different categories as to what's necessary for them to be approved. So cases that meet all eligibility requirements and contain positive references, staff will make those determinations. And then there are cases that have been reviewed by the working group. Staff will make determinations on those cases. No.
And one point on that, what happens when somebody comes back with nothing but positive references, but is known by, I guess now, a member of the working group not to actually meet those capacities, and such as they've been sanctioned by the court or had their entire practice taken over, yet they've gotten 3 people that don't know that their practice has been taken over. How do we handle those situations?
So let me just ask this. In our applications, do we do like a background check with if somebody's been sanctioned by the court?
Whatever state board.
Yeah.
I mean, it was unique for us, but only because we had 11 different members of the commission, which exists no more. What happens if the working group happens to know that, for instance, the court has taken over this practice? It's not part of a state bar record yet, but this person would otherwise appear to be qualified, and their recertification application is up, but we happen to know, and then we can go get 35 different negative recommendations for that person, which overwhelms the process and gives us a basis for holding up that recertification.
Yeah, on the BLAC, we had a situation where on the 4 corners of the application, everything looked fine, but a group of us had seen this one lawyer in court where one of the judges would not allow them to appear by phone anymore. One had their electronic signature, electronic filing privileges taken away. Discovery sanctions are not reportable to the bar. Their interaction with other lawyers are not reportable to the bar. But at the commissions, we were the eyes and the ears in the trenches that saw what our colleagues wouldn't report for the certification or recertification, and none of you will be able to see that. So what is the plan, again, the plan to address that public interest? Again, it goes back to protecting the public interest. Okay? How are you going to protect the public interest from someone who does not need to state certain things, but the public should know? What's the plan to protect the public interest?
I guess the working group have that.
I just want to pause this because I feel like in the last time, and I know that our group will continue to rapid fire questions, so at least give Amy the opportunity to address them one at a time.
I apologize.
Oh, yeah.
Lawyers, we just kind of.
So the public member has to get you to stop talking, Lou. That's
well, you've asked me to stop talking.
No problem. Well, let me highlight the next screen also as to what the staff's going to bring to the working group, because I think that will make this conversation more comprehensive. So the next item is...
Well, but hang on. I don't want to just move on if Mark had something that was different.
Well, but Mark's question was, what happens if there's something that's that's missed in the application, that's missed in the review process because we receive these positive references? What is the safety net around some of that? Okay. So I think if
I just want to make sure I didn't cut him off too soon.
Oh, yeah, no. And
Thank
I think
you.
Lou had an example of that same scenario.
Perfect.
So if you look at also what staff is planning to bring to the working group, and I don't mean to, it's up there on the screen, that is cases that meet eligibility requirements but that have alternative tasks and experience. And then cases with neutral references or fewer positive references, and those that do not have a do not recommend in their references, those will be brought to the working group. Given that that is the process, I think the question about how do we ensure that we don't have somebody who I guess maybe erroneously or fortunately had positive references and perhaps something have some underlying issue within their work history that would present an issue, a public protection issue, if they were to be specialized. I think one thing that we can do as a safety net is go back and revisit the applications. We can bring them here to review if there's something that we need to add. For example, like a background check in terms of any sanctions posed on that person individually. I mean, because the other issue we're going to have, sorry, Roy, let me just finish this statement, is let's say all of these went to the working group, and we are now reduced. I mean, if we're having a hard time getting 5, and let's say we managed to be able to do that, to get 5 working group members. We have 58 counties. What are the chances of these 5 knowing the reputation of absolutely everybody in this arena? I mean, it is a real concern, even with a working group member. So,
I would say, 1, the chances are greater than 0.
Yeah.
But 2, it's my understanding because I think I had made the suggestion at a previous meeting that at the very least, every single application, regardless of whether or not how rote it looks, at least be given, like the working groups be giving access to them for some sort of period, like a 14-day kind of like objection sort of period. It's my understanding from how this is laid out that suggestion was not taken, and there will be certain applications that are approved without any member of the working group looking at them. Is that correct?
Yes.
Okay. That seems. I mean, I think what we suggested at a previous meeting was a pretty good middle ground of at least giving the working groups just a chance to chime in, and they could be the way I think I suggested it was that they could be flagged as, hey, by the way, these are applications that our staff thinks are smooth sailing, but hey, folks, you're part of the working group. Just let us know. 9 times out of 10, heck, 19 times out of 20, heck, 99 times out of 100, they're probably going to be like, yeah, they're fine. That one time out of 100 where they catch somebody saying, hey, wait a minute, yeah, I dealt with that person. Like the judge yells at that person every 5 minutes and took away their e-filing privileges and something. I would be very concerned that we have specialists being certified without a single other specialist looking at the application.
Yep.
Okay. So what I presented here is what our new rules state. But I just want to turn to our general counsel and ask, would there be anything to deter us from maybe adopting Roy's suggestion? And that is asking the working group, like, hey, we're going to keep these applications active for 14 days. Before we sign off, can you read these and do you have any concerns about these applicants?
So I think what we need to do is go back and take a look at our rules and make sure that whatever we're going to plan still complies with what the rules say. Okay. But we can put it on our list of things to do and get back.
Because the one issue that we have found a conflict with is, and this is why that item has been withdrawn. If you'll look later on in the agenda, the item that was withdrawn was the review of CBLS or the affirmation of CBLS of certifications and recertifications. That was withdrawn from the agenda because the rules now have created CBLS as an appeals body for anybody who's been denied. So you really wouldn't be able to affirm and serve as an appeals body. So for that reason, we're no longer going to be bringing certifications and recertifications to this group. So now, if this moves on to the working group, I think we need to, the review of initials or certifications or recertifications, we really need to look at what that impact might be, because it would have to go to the working group, because it would not make sense for it to come to the CBLS.
Just to make clear, like I'm talking about essentially a speak now or forever hold your peace.
Yes.
Period. Where these applications can be deemed conditionally certified. Like these have been conditionally certified, subject to this 14-day period. If anybody objects, and when 15 days is up, they're like boom, like nobody objected to them. I just would like at least the process, and I think the public would have like more faith in the. It's like look, they're put up to the eyeballs of these working groups, like formed by specialists that have either volunteered in the past or continue to volunteer in these specialties.
If I can ask a question, I guess, of general counsel. So how much autonomy does staff and the board have in terms of implementing the actual steps and procedures following the rules that are coming from the Board of Overseers? Like you said, we have to go back to the rules, but how much autonomy does staff have to implement those procedures?
So it's appropriate to have guidelines, but they just have to be within the rules. They can't go beyond the rules, and they can't contradict the rules.
Sure.
But to the extent that there's ideas and procedures that could be laid out, yes, that is possible.
And but does it then have to go back up for reapproval, or as long as it's within the guidelines of the rules, it's the autonomy lives at staff and with this body?
Correct.
Thank you.
And what I'm thinking about in terms of the working group, I mean, I think that's where we have greater flexibility as to whether we take on this task. But if we ever had a working group member that eventually will become a CBLS member, and they've participated in the initial review of the certification or recertification, it might present a challenge if that person gets nominated on the CBLS to serve as an appeal body for that case. So it's just something that we have to control and we need to talk about. But is it doable, and does it seem appropriate to address the concern that no specialist has signed off on those that meet all of the requirements and get positive references? It will help address that. I think we just the Office of General Counsel and us, we have to put our heads together around how to address that. Okay. All right. So these are the requirements that we have established for working group members, and we talked about this in the past already. They need to be a current State Bar of California licensee, current or former certified specialist, available to attend the working group meetings, and have knowledge of the legal specialization rules, standards, and related State Bar rules.
Can I just ask one question on the former certified specialist? Former would imply that they left being a certified specialist on their own, that they didn't have their certification revoked or something along those lines?
I think we're thinking more retired.
Okay, thank you. Yeah.
Okay. Retired or judges. All right. Okay, so where we're at with our volunteer interest. So as you can see here, this is after soliciting from our last pool of advisory commissioners. We have roughly 11 people interested in serving as working group members, 12 as graders, and 9 in exam development. And this is something that we could keep tracking to help, again, address and strategize around some of the gaps that we've identified and discussed earlier.
Taxation and family have 0 across the board.
All right. Okay, can we now move on to number 2?
Oh no, Amy. We're gonna
Okay, so my last item is on recent developments. So, on recent developments, I want to talk about Ames. This question was raised recently, earlier, and so where we're at with Ames, I talked about the fact that we implemented Ames on March 1st, and since that time, on March 1st, we opened the application process for the July bar exam, for the first year exam, and also legal specialization. So these applications were available online. So since the time of March to now, we have now gone through 1 exam cycle, or perhaps 2 exam cycles, as well as 1 iteration of grading online to determine how the system has been functioning. What we've identified is problems in the system throughout the process. So one problem that we've identified has been data migration. So data that was migrated from the AS400 is not being successfully implemented into the new case management system. And so, and there are different circumstances and impacts that it has. I'll give you an example. Eligibility is one of the criteria in determining whether somebody can sit for the bar exam. So when you register, the application comes to our staff, and our staff does a background research to find out whether or not somebody could sit for the bar exam. And that theoretically should only happen one time, because if you're eligible at one point, that eligibility shouldn't go away, right? Theoretically. So, and the way that determination is, the eligibility criteria is applied is we look to see, did we receive this person's JD? Or perhaps if they are an attorney applicant, did we receive their certificate of good standing from another jurisdiction? That data did not come through, so we had a lot of applicants that were deemed ineligible that required a lot of manual work because a variable did not successfully import or migrate into our new system. So that's just an example of some of the problems and glitches that we've identified in the system. So we have a list. Yes?
Why did that happen?
That's what we're trying to discover. So right now, we're coming up with a list of all of the problems to figure out their origin. So we're doing a root cause analysis to determine what are the problems, what is required to address them, and how do we prevent them in the future. So, whether it's a functionality issue, a data migration issue, a logic issue, we're in the process of assessing that.
Lou, that's a difficult thing to answer. And honestly, having done data migration, I know Cynthia can talk about this as well. There's so many places that things can happen, and I guess the bigger question is why wasn't there data validation done after the fact and seeing that things were done? But it's a difficult thing to answer, and the root cause analysis is going to get you there. But hopefully there doesn't have to be another data migration where you need to worry about implementing the root cause analysis.
Especially, yeah, since we've been on for 6 months, too.
Because that would imply you're moving it again, and you don't want to do that. So,
Amy, I have a question though. Do you have your consulting group with you still, or do you have to get new funding?
We're working with our vendor again to revisit this. But we're not sure how much they're going to take on, how much we're going to take on in-house, because since the system has been implemented, and I think it gets to what Lou's raised earlier, that is, do we have expertise in-house? And we have hired a Salesforce programmers in-house. So we do have
so then
some
you have
expertise
some process to iterate and either evaluate issues or add new enhancements as you move through your application?
So we went through all our JIRA tickets to evaluate what was pending, what was left for a future phase, and what are current issues to prioritize what needs to get done. Mm-hmm.
So you have that in-house knowledge then?
That
will allow you to enhance as you need.
And we're relying on the tool that they have left behind, which at this point has been JIRA, as our documentation for the design from the design process and on where our current standing is on both the functionality and the data migration issues.
And my last question is if there has been a knowledge transfer from the consultant to your in-house knowledge.
Oh, yeah. We had knowledge transfer sessions set up before they left. And so, so that had already happened. Mm-hmm.
Thank you.
All right. Great. All right, so now we also want to congratulate our new officers. So I want to thank both Rob and Roy for volunteering, and also congratulate both of you for coming on board. I want to talk a little bit about, just give everybody the heads up. I don't know if you saw the announcement, but our new members, Norma Acosta will be coming on board. She's in workers' compensation. Jeffrey Hammerschmidt, he is coming from criminal. Avi Levy is coming from family law. And Natalie Vance will be joining from legal malpractice. And with that, we also want to thank our outgoing members and for your time and dedication to this program. So, thank you. Now, as you may recall, there was one of the directives. Oh, great. Come on in, Lisa. So one of the directives from the board for all sub-entities was to have a standardized onboarding process. The first one is scheduled for October 4th, so I want to give everybody the heads up. Invitations will be going to each of you on October 4th, for October 4th for training in Los Angeles. And the training is going to be an onboarding on some of the things that some of you may already know, but it's just a way of standardizing it. So, for example, things that are going to be covered there are the conflict of interest policy. Given that ours has not been replaced, we're going to do conflict of interest policy training on the CBLS one. We're also going to conduct, training on some of the basics, like, for example, doing the travel claim process. What else? I can't think of anything. I can almost visualize the agenda, but it's a basic onboarding.
Mark, myself, and
yes, you guys will get an invitation as well as the 4 new members. So you'll probably meet the new members at that meeting on October 4th. Just a heads up. Those are my last updates. But before we do that, where did Lisa go? Oh, here we go. So I want to introduce everybody to Lisa Cummins. She is our program manager overseeing the bar exam development, and she's been helping us create our both our ledge team and determine our processes for how we're approaching grading, exam development, and so on. Also, I just want to give Lisa's background. So Lisa served as a committee of bar examiner volunteer for I don't know how long before she came on board. 3.5 years. And she also served on the Ginny Commission, didn't you? And so then she became a staff at the admissions. And I'll let you take it over, Lisa. So I just wanted to let everybody meet who has been interfacing and carrying out some of the functions of legal specialization in the Office of Admissions.
So I had a doctor's appointment this morning, so I apologize. But I appreciate meeting you all. I've been sort of tangentially involved in, getting more involved in the exam development portion of this for the upcoming October administration. And my background is that I practiced law as a civil litigator for many years before I transitioned to the state bar, and I started about 2012. And So basically, since I started here, I've been overseeing the development of the bar exam as well as overseeing the testing accommodations. So when applicants to your exam file requests for testing accommodations, my staff takes care of that. And then the bar exam, the first year law students exam, I oversee those developments. So the legal specialization exam is a little bit different, but we're trying to make it come into somewhat of an alignment with how we develop the bar exam, and it's been a very interesting process. I appreciate getting to meet you all today.
Okay, so I think with that, we're done with this portion.
Thank you. Thank you for joining us today. So that does close the first session. We'll move into the consent session of the agenda. With the approval of the June 14th minutes from the California Board of Legal Specialization public meeting. Everybody should have received it. If not, it's in front of you. If we can all take just a couple minutes and review any comments, then we'll go from there. So let's take a minute or two to review last time's minutes. So I raised the question, and what's being looked into is that from the June meeting, was not physically present here in the San Francisco office. I was remote from the LA office, and it's not reflected in the minutes, and so we're just discovering whether or not it's important that it's reflected in the minutes or not. Sorry. This is my fault this time.
You're the troublemaker.
Yes. Yeah, Lou wasn't there.
I mean, we think because the agenda noted that, there was a person from their own location calling in, that it doesn't need to be in the minutes.
Perfect.
Okay.
I just wanted that clarification
Okay.
before we move forward. So, okay, then if everybody's had an opportunity to review, are there any questions about the minutes? Okay, okay, we have a move in second. Let's go ahead and, well, this time we're all here, so we can actually just take a vote in person. All in favor? Do we need to do roll call for approval? Just all right. All in favor of approving the minutes? Aye. Any opposed? No abstentions. The motion carries. Okay, that closes the consent portion. We'll move on to business. In Section A, report on financial and operational key indicators. And Amy, back to you.
Sure. So I lost my spot. There we go. So this is an item, a standing agenda item that looks at operational and financial key indicators as a way of measuring program health. If you look at the budget aspect, unfortunately, we did not have a Q2 statement available. The board, it's being developed right now for the board meeting that's coming up on September 19th. So what we're hoping to do is at our next meeting, at the December meeting, that we'll have Q2 and Q3 available. So we don't have an update on those reports. Now, the other three measures. One is the total number of specialists. If you look, there is an increase compared to last year. In terms of resignations, we do have a slight bump up in 2019. But if you look at those, a lot of those resignations are due to retiring attorneys, which is anticipated given that the program is in its 37th year. As for the legal specialization education compliance, so right now Group 1 is a compliance reporting period, and that deadline we talked about at a previous meeting was extended to July 1st. 107 specialists in that group are still pending compliance, and this will appear again at the next agenda as to next steps for that compliance group.
Amy, I have a question for you on the total number of specialists, just from an analytics standpoint. It's a slight increase from a year ago relative to the increase or decrease in, I don't know, the total licensees of the State Bar. Are we running in parallel? Is it, are we seeing a greater increase, decrease parallel to what the overall admission into the bar is?
So I know that last year when there was an analysis of comparing the number of specialists to the number of overall
new
licensees, we were at 3%. We haven't done that assessment, but we could do it for the next meeting just to find out where we stand.
Yeah, it'd be interesting to know if we're tracking with the overall number of licensees.
Yeah, we can do that.
Thank you.
All right.
What is the plan to encourage members of the bar to seek specialization?
Oh, good question. What we are doing is we are doing some outreach. So we had State Bar staff attend the CAUC conference, and we are going to be attending outreach efforts at the next, it used to be sections, and it's now the California Lawyers Association. So in October is the next event that our staff will be participating at. We also participate at each of the swearing-in ceremonies, and despite the fact that for people relatively new, I think it's a matter of being seen and putting ourselves out there. So
we've attended a few together.
Are you going to do that with staff, or are you going to do that with certified specialists?
We could do it with both, as we've done in the past. The next one is coming up in December.
So sorry.
No problem.
So we're moving on to B, report on legal specialization examination, post-examination application statuses. And Adrian, over to you. Oh, I'm so sorry. Thank you. The report. So what report? This was what you just handed out. Is what's being. And the attachments. Okay. So if everybody would just take a few seconds to review what was just handed out, and we'll need a motion to then to accept it. The subsection A, the report on the financial and operational key indicators. We need to receive it in.
It just says receive and file on the agenda item, so I don't know that you need to approve it. Yeah.
Okay.
Yeah, and there's no motion on the agenda. So.
Now it's Adrian causing the problems. No, that was
That's what we just explained.
The board is still compiling them, and we'll do 2Q and Q3 at the next meeting. That's correct?
Mm-hmm.
Yeah.
Yes, in December.
But and the financial will continue to show what we're doing on the loan from CBLS to the bar, right?
Yes.
Okay, thank you.
It'll be in the same format as the last one, which I think is what you had requested.
Right. Finally saw a balance sheet. Thank you.
Mm-hmm.
So, Adrian, over to you.
So, item 3B, it's the report on legal specialist exam, post-exam application statuses. Those successful applicants of the 2017 LSX, they had until April of this year to file their application, or they could ask for an extension of time up through January 31, 2021. As of August 30th, 68.9% of those candidates have filed their post-exam applications. Attachment A shows a breakdown of those candidates. Estate and family, they received the most post-exam applications, accounting for more than half of the total received applications. And then once again, the remaining applicants will have until, they may have until January 31, 2021 to submit their application.
And just a quick question, are these numbers kind of in line with what we've seen before? Just in terms of like the percentage of people that have actually gotten around to doing the application?
I would say around this time of year, it would be.
Okay.
Yeah, I'd like to ask that we do see like previous period statistics when we look at these, so that we can really judge the overall health of the program, knowing where we're going. You know,
so like point in time.
Yeah, right. So we've got, you know, if you're looking at Q1, Q2, you know, it's good to see what previous period or period last year, just some sort of point of reference, so we know what does this mean.
Where they were in 2017, at this time in 2017,
right,
relative to 2015.
Correct.
Because 2017 is in there, but you want point of time as like whether we want to call this quarter 3 or whatever the case may be.
Right, like
on track.
From this distance from the exam.
Got it.
2 years ago, whatever.
Correct.
Okay.
We'll have that for the next one.
Thank you.
So I don't know if we're going to receive this one or.
Yeah.
That one, there's nothing. It
No
was
action.
just to receive. There's no action needed. And now we're moving on to subsection C. This is actually approval of the advisory commission and staff recommendations. Yes.
That's the one that has been withdrawn.
This has been withdrawn. I apologize. So we're skipping C to D. Approval of proposed certification revocations for failure to pay 2019 legal specialization program annual fee. And Adrian, if you can go over the bullets, please.
Sure. So this is 3D. This is for, approval of proposed certification revocations for failure to pay the annual fee. Just some quick bullet points. The legal specialization program is self-funded through the fees paid to the program. Specialists are billed this fee every year on their annual fee statement. There are currently 52 specialists that still have a balance related to the program annual fee, and there's a staff recommendation for revocation for failure to pay. And then attachment A lists those specialists.
Okay, gotcha. Thank you. Okay. So we do need to take action on this. So do we have a motion from the floor?
So moved.
Okay. Second? Second from Mark. Okay. So those in favor then of following staff recommendation, which is for revocation of their certification. I'm sorry, Janet.
I am abstaining from workers' comp.
Noted. Thank you. So those, all those in favor? Aye. Does everybody need a few more minutes?
Well, I just had a follow-up question. Has the final communication already been sent out? Or are we going to send that out and then?
It will go out after this meeting, if you guys.
Okay, so we'll send it out then 30 days if they don't respond.
Yeah. So if you guys approve this motion, staff will send out a letter, and they'll have 30 days to respond.
Okay, so I think I need to restate the motion. So the motion is that we're going to approve that we're going to send out notification that they have 30 days to respond, or they will have their certification revoked.
Scream or die. Do something in 30 days.
I think we need a little bit more than scream or die as the motion.
And they will, like, my understanding is they'll be revoked with no further action from this board.
Right.
Okay. All right.
Okay. So do I need to restate the motion is that we're approving staff's recommendation that a notification will go out after this meeting that they have 30 days to come current on their fees, or their certification will be revoked with no further action from this board. Anybody with?
I'll second. We're giving them extra. I'll second that. I thought I seconded already.
So then we need a first.
Well, I'm so moved.
Okay, so Roy.
Move. Second.
Okay. All those in favor? Aye. Any opposed?
No.
And we have one abstention from workers' comp. Okay. So we move on to, we are now on E, approval of proposed certification and revocation for failure to report Group 1 legal specialist continuing legal education compliance. Adrian.
So 3E, similar to the previous item, will be revocations except for failure to report their Group 1 legal specialist continuing legal education compliance. Some quick bullet points. Their specialists must report 36 hours of the CLE on the same schedule as their general MCLE reporting. There are still 107 specialists still pending the LS-CLE compliance. Staff recommendation is to revoke their certification after sending a notice, so they'll have 30 days to respond, or they will be revoked with no further action from the CPLS.
Do you know how many members on this list are also on the prior list that we just voted on?
There are. I'd have to look at it specifically.
Okay.
There are some that are on both lists.
Okay.
Yeah.
Because it sounds like a lot of numbers, but I guess it's a combination. They could be on both lists.
Okay.
Janet has a question.
Janet.
I don't know if it makes a difference, but if you go down to just short of the bottom, Julie Fang, listed as active in workers' comp, is a judge now. I don't know what she is. It's a judge.
So we can.
You have a legal malpractice. You have a judge, Wendy Chang. She shouldn't be on that list.
Is there an echo?
There's no automated way for judges with the state bar to toll their certification. The requirement is that they have to submit a tolling request to the department. I've actually reached out to Judge Chang a number of times, but we can modify this that I will reach out once again to, I guess, Judge Fang and Judge Chang one more time. And then we can take them off the list from this motion.
And also, my question would be, how many of these people did not report their general MCLE requirement?
Oh, good question.
If I had to guess, it would be, I'd have to check, but I would say, if anything, it would be the 3 inactives on the last page, because maybe they were inactive for not reporting their MCLE. Because if you hadn't reported your MCLE, you would already be.
Oh, that's already like when did that hammer?
Wes
drop?
may know. Do you know Wes?
Yeah, it was on July 1st. Anybody that did not report that they were placed on an administrative inactive status.
Oh, so these people they all reported their regular MCLE, but not that. Oh, okay.
And then there's 2 not eligible. What's the difference between not eligible and disbarred, I guess?
Normally, what happens is they've been suspended from a previous reporting cycle, and depending on the status of how they were suspended, they were still supposed to continue their MCLE. So when they're not eligible, meaning they were suspended as opposed to placed to an inactive status, administrative, it could be discipline. It could be a number of things that are there.
So I have a question. One of these individuals is listed as disbarred.
Yeah.
Wouldn't that be an automatic revocation?
We had that conversation before.
We did?
Yeah.
It's not.
There's no automated process. The rules, I'd have to look up the specific rule, but anytime we suspend or remove the certification, we have to give them 30-day. We have to give them a notice, and then they would have.
They can still claim to be a certified specialist.
Correct.
But
We can't just take it away without notifying them.
It's a neat trick.
I would put in a request for a future agenda item to see if the rule could be changed in that respect, because that really doesn't seem to make any sense at all.
It didn't then either.
In addition, there is a person on this list who is the exact person I brought up in an earlier conversation about. I think we have 25 recommendations for not being recertified, and apparently she's now going to get a letter that because she failed to send in your MCLE, she could be recertified. I just want to make sure that that's not, by sending that in, that's going to suddenly qualify her for recertification purposes. And it's why I happen to be on here at the time when her name comes up is beyond me, but that's why you want to have practicing attorneys out there.
Yep.
Okay, so I'm a little bit at a quandary of how to proceed right now.
Can we look at the motion? Because I think there's a few caveats. I mean, there was questions about how much overlap there is with the previous list of annual fees as well as this. There's an issue about how to address judges that appear on the list. The disbarred, it seems like it is an administrative issue, disbarred and disciplined. That the reason they're on this list is of the administrative process of keeping somebody on for 30 days. So I don't know if you want to add any of those items to the motion itself or any action to those 4 conditions to the motion itself.
Well, I would move to carry the motion forward as written, because if they're not responding, then I would recommend that the staff take action on that.
Okay.
But those other issues, I think, definitely need to be addressed administratively.
And then, Donald, you added also the recommendation that we look at a rule change for disbarred attorneys and how
and also for non-eligible attorneys.
Okay. So then we could put that on an upcoming agenda.
Well, I guess if someone's not eligible, but then they do what they need to do coming out of an ethics violation, so then they come in compliance, should that attorney then be allowed to say they're a certified specialist, or does that come up in the recertification process?
Right. More to the point, given the, I mean, this is not a question for this particular item, but given the proposed changes about potentially receiving advice from non-lawyers, would we possibly be getting in a situation where somebody could not be a lawyer but technically be able to represent themselves as a legal specialist if they've been disbarred? I mean,
Yeah, I think that's what we want to explore at a future
Right,
date.
right.
Yeah,
No,
but,
we definitely
But I think
want
what
to
you're
explore that.
saying sounds like it is the current process, right? I think that's what we're
Right.
trying to address.
Well, I
Yeah.
guess the issue is that if the state bar allows non-lawyers to practice law, and so, no.
No, we don't, non-lawyers cannot practice law.
So educate me. What is out there that they're talking about? This subcategory, it sounds like, of, was it non?
Yeah, I'm not that clear on
I'm not that clear. I mean, you kind of hear things. Is the state bar exploring some type of program that would allow non-licensees to somehow provide legal services? Because we're concerned that you can have a non-licensee, let's say, who's been disbarred, and they say, well, I fall into this other category, I'm a specialist, and it just, to me, it's confusing. I'd like to be educated on it.
So currently, there is no rule allowing non-lawyers to practice law.
Okay, that's good.
Definitely.
Okay, is that good enough?
That's good.
Definitely.
Okay.
Yeah, definitely.
Well, but I do want to
But is there something being explored?
There is something on the upcoming Board of Trustees agenda that will be discussing referral services and how that works with the current rules of professional competency.
Okay.
So I'm not working on it. I don't know really
Right, and
the
you're out
ins
in
and
2
outs.
weeks.
Yeah,
And I'm out in
that's
2
okay.
weeks.
You don't have to deal with that. That's fine.
It's an issue that's coming up, but it is not in effect right now.
Okay.
But I also want to recognize that we do have a special admissions process for people who are not licensed in California to practice law under very specific conditions and registered with us, such as registered in-house counsel, registered legal services attorney, or they're now called registered legal aid attorneys, and so on. So
I think all
that's a separate program.
all our concerns would be answered with a one-line change. It's like, if you are not an attorney in good standing, you cannot represent yourself as a legal specialist.
Yeah.
That
we
would-
will
that would be-
agendize that for a future discussion.
And we would
Yeah.
need to clarify an attorney in good standing in the state of California.
Right.
But, I mean, because you've got people in some areas that may be more
Yeah,
federal that
it's an easy
can try to get specialization.
Yeah, so all this discussion should come up next meeting when it's on the agenda.
Right.
Yeah,
we do that.
and the motion,
Yes, I just
by the
want to
way,
get my point out.
Yeah.
And I just needed one clarification about one certain person. Is her has it been approved? And so the only thing she now is not in compliance with is that she hasn't reported her legal education requirement.
So let me add, based on the motion, we're not actually moving to give anybody their certification. All we're doing is moving that if they don't respond, it will be revoked.
So there would still be a review of the application once they respond.
Right? We're not approving any. So the motion is that those certified specialists listed on the attachment are revoked for failure to comply with the requirement if no response to final communication is received within 30 days. There's no affirmative action taken where anybody's getting anything based upon what we're doing here. It's absolutely revoking it for failure to reply. Fair? So I think it's, Mark, I think in your situation it's covered. We're not actually giving anybody their certification. We're just saying it's definitely going
clarification, I'm
away.
good then.
So,
And can I ask for one point of clarification? The notification, will it be in writing or by email?
You can specify. Generally, we've been doing digital, like email.
I would recommend in writing just because it may be both, but I mean, some people will have email going to spam and may miss stuff and may inadvertently put a name on a do not send list, and then they don't get any emails from that whole entire organization.
I would say the last known email address on their profile and the last known address on their profile.
I happen to know one of the guys on there. I've just emailed him. Got to have it pulled if he doesn't get his MCLE.
okay, so does somebody want to make the motion?
I'll make the motion.
I'll second.
Those in favor?
Aye.
Opposed? Okay. Any opposed? No, we have just Janet recusing herself from workers' comp, and the motion carries. And that takes us on to subsection F, which is the review of the international, no?
Oh, yeah, sorry.
Yes, review the International Association of Privacy Professionals, a IAPP, application for accreditation of specialty certification program in privacy law. And Adrian, please. Yeah, Adrian, are we taking some time for the review?
You can definitely take some time to review, but I guess so the IAPP, is the International Association of Privacy Professionals. They are applying for accreditation of their specialty certification program in privacy law. The IAPP, they were approved by the ABA in spring of last year for this specialty program. Their mission, promote and improve the privacy profession globally. They have more than 50,000 members worldwide. For the privacy law certification program, specifically, 61 attorneys have completed their program. 10 of them are licensed here in California. They note on their cover letter, that's the first page, they've been seeing consistent growth and they're projecting more. And then on the fifth page, it lists their specific attachments regarding their program.
Quick skim.
So there's actually no action necessary today. This is a lot of information that we can review. There was an oral report, and Adrian just delivered. We can take a couple minutes to review, but we can propose action for the next agenda.
And I would say even too, for the next agenda, I can request to have someone call in from the IAPP to possibly address any of you guys' questions.
So Roy, would you like to make a motion to put this on your first agenda?
It's going to take me a better part of my next meeting to do that. Yes, also.
The motion is to actually, what are you moving?
I'm moving to put this on the agenda, our next agenda for
Wait, hold on. We're moving to, is the agenda item for the next one that is to whether we're going to accept it into the program, or what are we going to be talking about next?
That's
yeah, to accept?
Did I say review? I'm sorry, yeah, it's not on the next agenda to actually approve or
Yep. And we have seconds still? Okay. All those in favor?
Aye.
Aye. Any opposed? Any abstentions? Okay.
So I just want to add one quick thing. I think this is the second specialty request or request for specialization consideration that has come to the group. I think one of the things that would be beneficial is to revisit the policy and considerations that that the CBLS has in terms of what criteria you want to use for adopting a new program. We've gone back to look at in the archive of what traditionally has been the criteria that we've used, and so perhaps we want to bring that criteria here to see if there's anything that we want to reshape, reformat. I mean, I know that when there was a discussion at the board meeting about CBLS, the idea was perhaps for the CBLS to explore specialties that enhance the direction and some of the state bar goals, such as diversity or access to law in general. So I think it'd be a good discussion. We could put it on a future agenda because it has not been agendized, but I think it's relevant to our discussion today on this item is to create some guidance or guiding principles as to how we evaluate these applications.
That's an excellent idea.
Yeah.
Okay.
Have context in which to take a look at this overall.
Yes.
And
Okay.
the question for the Office of General Counsel is what are there specific rules and parameters as to what constitutes what we can actually accept as a specialization program?
There are no rules around that. I think there are rules as to what needs to be considered, not criteria. What I mean by that is like what information that we need to act on. But we'll bring all of that to the next meeting before we dive into that. So guiding principles and the rules related to what's acceptable in an application.
I guess the question is, are we going to be in a position to actually approve or deny before we have the opportunity to review that? Do we need that first? I'm looking more towards the board in terms of, your preparation, our preparation for being able to take action.
I'd love to have that information. What are the guiding principles when looking over this application?
Yeah.
So then what we'll do is at the next meeting have that discussion in terms of the policy of development on what criteria we want to use when looking at these applications, and then perhaps put this on the next agenda after that's been determined. Okay.
Okay, from just a rules of order perspective, we've already had a motion to put this on the next agenda. Do we need to make a revision? What do we need to do?
Yes, you probably do.
So I'll make that new motion that we put that consideration of this application for the IAPP 2 meetings out here, and that at the next meeting we will consider the parameters and the requirements for what constitutes an application and the things that we should be considering when looking at for consideration of specialization.
Okay. Those in favor? Aye.
Aye.
Opposed? No abstentions? So the motion carries. And I believe that takes us through the end of the open session. So I want to publicly, personally thank the 4 of you who are, this is your last meeting, and it's been great to get to know you over the past few years. For me, I know for other people for a long time, and really appreciate what you do as a public member. Honestly, didn't realize that before getting involved, that passing the bar, I thought it was like medicine. You become a doctor, but you don't just practice in the whole part of the body. You learn about a specialty, and so knowing that and being involved in this program has been very eye-opening, and that's why I'm a little bit passionate about it. And I appreciate the work that you guys have done. So I will miss seeing you guys at the meetings. And that being said, this officially closes the open session at 10:44.